On February 21, 2023, the Supreme Court of the United States heard oral arguments in a case that could have rewritten the fundamental rules governing the Internet. Gonzalez versus Google LLC centered on a single question: does Section 230 of the Communications Decency Act protect YouTube when its algorithm recommends content? The courtroom was packed. Tech companies, civil liberties groups, and victim advocates all watched closely. At the heart of the case was a tragedy and a family seeking answers about whether YouTube bore responsibility for what its recommendations had done. The plaintiffs were the family of Nohemi Gonzalez, a 23-year-old American student studying in Paris. On November 13, 2015, she was killed in the coordinated terrorist attacks carried out by ISIS across the French capital. 130 people died that night. In their grief, her family began asking difficult questions. They learned that ISIS had used social media platforms, including YouTube, to spread propaganda and recruit followers. And they discovered that YouTube's recommendation algorithm had actively suggested ISIS videos to users who had shown interest in related content. The family believed YouTube had done more than host content, it had promoted it. For more than 2 decades, Section 230 had been the legal foundation of the modern Internet. Passed in 1996, it grants platforms immunity from liability for content posted by their users. The law states that no provider of an interactive computer service shall be treated as the publisher of information provided by another. In practice, this meant YouTube couldn't be sued simply because a user uploaded an ISIS video. The law had allowed platforms to grow without facing endless lawsuits for every piece of user-generated content. But the Gonzalez family argued that YouTube had crossed a line when its algorithm began recommending that content. The central legal question was deceptively simple: when YouTube's algorithm recommends a video, is that still protected by Section 230? The plaintiffs' lawyers drew a sharp distinction. Hosting user content passively, they argued, deserves immunity. But YouTube's recommendation algorithm was anything but passive. It analyzed user behavior, predicted preferences, and actively pushed specific videos to specific users. When the algorithm suggested an ISIS recruitment video to someone searching for related material, YouTube wasn't merely providing a neutral platform, it was, the plaintiffs contended, curating and promoting that content. That, they said, made YouTube a publisher, not just a host. In their briefs and during oral arguments, the Gonzalez family's legal team made their case. They acknowledged that Section 230 protected YouTube from liability for simply hosting videos uploaded by ISIS supporters. But recommendations, they insisted, were YouTube's own speech editorial decisions made by the company's proprietary algorithm. By choosing which videos to surface and promote, YouTube was acting as a publisher. The algorithm didn't recommend videos randomly, it was designed to maximize engagement, to keep users watching. When it recommended ISIS content, it amplified that message and helped the terrorist organization reach new audiences. The family argued this went beyond the immunity Congress intended to grant. Google's attorneys countered with a stark warning: ruling against YouTube would upend the entire Internet ecosystem. They argued that recommendations are an inherent part of organizing and displaying user content, which Section 230 explicitly protects. Every platform, from Google Search to Facebook's news feed to Twitter's timeline, uses algorithms to sort and present content. If recommendations lost Section 230 protection, platforms would face unlimited liability for every piece of content their algorithms surfaced. The consequences, Google warned, would be catastrophic. Platforms would either shut down recommendation features entirely or face endless litigation. Innovation would cease. The modern Internet, as users knew it, would collapse. Major technology companies and industry groups filed amicus briefs supporting Google. They painted a picture of a digital world in chaos if Section 230 were narrowed. Reddit, Twitter, and smaller platforms all relied on algorithmic sorting to make their services usable. Without algorithms, users would drown in unfiltered content. The briefs argued that Congress, when it passed Section 230, understood that platforms would need to organize user content, and that's precisely what the law was meant to protect. The case, they warned, risked creating a legal framework that punished platforms for trying to improve user experience, forcing them to choose between being useful and being sued. During oral arguments, the justices grappled with the implications. Some seemed skeptical of the plaintiff's distinction between hosting and recommending. Justice Elena Kagan asked whether every website that displays content in a particular order, by chronology, by popularity, by relevance, would lose Section 230 protection. Where, exactly, would the line be drawn? Others appeared troubled by the idea that platforms could amplify harmful content without consequence. Justice Clarence Thomas, who had previously expressed doubts about Section 230's broad interpretation, probed whether the law was ever meant to protect algorithmic curation. The questioning revealed a court uncertain about how to apply a 1996 law to 2023 technology. Much of the argument focused on understanding how YouTube's recommendation algorithm actually worked. Google's lawyers emphasized that the algorithm didn't favor ISIS content, it simply responded to user signals. If someone watched videos about extremism, the algorithm suggested related videos, just as it would for cooking or music. The plaintiffs countered that this was precisely the problem. YouTube had built a powerful engagement engine without adequately considering the consequences. The algorithm treated ISIS propaganda like any other content category, optimizing for watch time rather than social harm. The justices pressed both sides on technical details, revealing the challenge of adjudicating algorithmic behavior within traditional legal frameworks. The court had also agreed to hear a related case, Twitter versus Tamna, which dealt with similar issues of platform liability for terrorist content. That case involved attacks in Turkey and asked whether platforms could be held liable under the Anti-Terrorism Act for knowingly providing substantial assistance to terrorists. As the justices heard arguments in both cases in consecutive sessions, it became clear they were looking for a way to resolve the immediate dispute without making a sweeping pronouncement on Section 230. The Twitter case offered a potential off-ramp, a narrower legal path that might deliver justice to the families without rewriting internet law. As the arguments progressed, a pattern emerged. Justice after justice expressed concern about the breadth of the question before them. Justice Brett Kavanaugh noted that Congress, not the courts, might be better suited to update Section 230 for the age of algorithms. Justice Amy Coney Barrett questioned whether the court had enough understanding of how modern recommendation systems worked to make sound policy. Even justices sympathetic to the plaintiffs seemed wary of issuing a ruling that could have unintended consequences across the digital landscape. The mood in the courtroom suggested that the court was searching for an exit, a way to resolve this particular case without deciding the fate of Section 230. On May 18, 2023, the Supreme Court issued its decision in Gonzalez v. Google. In a brief, unanimous opinion, the court declined to rule on the Section 230 question. Instead, it disposed of the case on narrower grounds, pointing to its decision in the companion Twitter case, which had found insufficient evidence that the platforms knowingly aided terrorism. Because the Gonzalez family's claims failed under the Anti-Terrorism Act, the court reasoned, there was no need to address whether Section 230 protected YouTube's recommendations. The justices had found their off-ramp. Section 230 remained intact, its application to algorithmic recommendations still an open question. Legal scholars immediately noted what the court had avoided. The fundamental question, whether algorithmic recommendations constitute the platform's own speech and thus fall outside Section 230's protection, remained unanswered. YouTube and other platforms could continue using recommendation algorithms without fear that this particular Supreme Court decision had stripped away their immunity. But the issue hadn't been resolved, it had merely been postponed. Future plaintiffs could still argue that recommendations exceeded the bounds of Section 230. Lower courts would have to navigate the question without Supreme Court guidance. The uncertainty persisted, the legal landscape unchanged, the debate deferred to another day, another case, perhaps another court. For the Gonzalez family, the decision was a profound disappointment. They had hoped the Supreme Court would recognize that YouTube's recommendations went beyond passive hosting and establish accountability for platforms that amplify dangerous content. Instead, they received a procedural dismissal that left the core issue unaddressed. Their daughter's death, and the role YouTube's algorithm may have played in spreading the ideology behind it, would not become the landmark that changed internet law. In statements after the decision, the family expressed frustration but also determination. They had brought the issue to the nation's highest court, forcing a conversation about algorithmic responsibility that would continue long after their case ended. For Google and the broader tech industry, the outcome was relief, not celebration. Section 230 had survived its most significant Supreme Court challenge, but the decision offered no affirmative endorsement of algorithmic recommendations. The court's reluctance to engage with the issue signaled that the justices saw the question as difficult, the stakes as high, and the existing legal framework as potentially inadequate. Tech companies understood that they had won a reprieve, not a resolution. Congressional proposals to modify or repeal Section 230 continued to circulate. Public pressure to address harmful algorithmic amplification intensified. The case had ended, but the reckoning over how platforms use algorithms to shape user experience and the consequences of those choices was far from over. The central question Gonzalez versus Google raised remains one of the defining legal challenges of the digital age. When does a platform's algorithm transform it from a neutral host into an active publisher? As artificial intelligence and machine learning become more sophisticated, recommendation systems grow more powerful and more opaque. They shape what billions of people see, read, watch, and believe. They can surface vital information or dangerous propaganda. They can connect communities or radicalize individuals. The Supreme Court declined to draw a line between protected and unprotected algorithmic activity, leaving platforms, users, and future plaintiffs in a state of legal ambiguity that reflects our broader societal uncertainty about who controls the digital public square. Gonzalez versus Google will be remembered not for what it decided, but for what it revealed: a legal system struggling to apply analog-era laws to digital-age realities, a Supreme Court hesitant to make sweeping pronouncements about technologies it barely understood, and a society divided over whether platforms should be held accountable for the content their algorithms promote. The case brought the Gonzalez family's grief to the highest court in the land, forced tech companies to defend their most fundamental legal protection, and put algorithmic recommendations on trial. In the end, the court chose not to choose. The question of YouTube's responsibility for what its algorithm recommends was left for another case, another court, another time when perhaps the law, technology, and judicial understanding would finally converge. Today, YouTube's recommendation algorithm continues to operate much as it did before Gonzalez versus Google reached the Supreme Court. Section 230 remains the law of the land, protecting platforms from liability for user content and, for now, the algorithms that organize and recommend it. But the case changed the conversation. It demonstrated that the immunity tech platforms have long enjoyed is not unquestionable, that the distinction between hosting and recommending is legally meaningful, and that victims of algorithmic harm are willing to fight for accountability all the way to the Supreme Court. Whether through new legislation, future litigation, or evolving judicial interpretation, the questions the Gonzalez family raised about YouTube's recommendations and platform responsibility will shape internet law for years to come. Their case may not have provided the answer, but it asked the right question.